Great. Welcome, everyone. My name is Kirsten Loita, and I head up our university relations team here at OUP. I'm so glad so many of you are joining us for this third webinar in a series of webinars on academic startup licenses. Some of you are returning to us, have been with us through the previous two sets of these webinars. If not, some of you may be joining us for the first time, and we'll talk in a little bit about how you can view the previous parts of this webinar series. So next slide. So I'll be your moderator today, as I mentioned, and then we have our three returning panelists, each of whom bring a different perspective to this conversation that we're going to have today. So in order for you to understand what these perspectives are, I'm going to have them introduce themselves. And Lisa, we're going to start with you today. Next slide.
Thanks. Hi, I'm Lisa Norton. I'm an associate director with the University of Washington's Office of Tech Transfer called Commotion. I'll be presenting today really from our public university perspective. I joined the office 17 years ago and managed a portfolio of primarily medical device technologies. And really, my interest has always been in applied research and how best to help bring technologies from the bench to the public. I really enjoy that means that I get to work with really smart, motivated people who are doing cutting edge research and to help them to find or sometimes even help create new ways to expedite that work going from a research project to a product. And today I'm looking forward to talking about how we facilitate that process by negotiating a license term sheet.
Great, thanks, Lisa. Rick.
Thanks, Kirsten. Hi, everyone. I'm Rick Friedman. I'm the founder of a boutique law firm called Novus GC that is dedicated to providing general counsel services to emerging technology and life sciences companies. I've been at large law firms and held in-house positions, but what brings me here today is a career detour I took 16 years ago when I joined UT Austin's Office of Technology Commercialization as a technology manager. I went on to head up the licensing team at UT, then USC, and spent a total of 9 years inside tech transfer. I returned to the practice of law 7 years ago and have been on the opposite side of the table since then, representing startups formed around university IP. So I come at this today from the perspective of the licensee or the startup side of thing, although I'd say I'm very, having been on the other side for 9 years, I'm very empathetic for the university side as well. Working with university-based startups and discussing tech transfer topics is always interesting, and I'm really glad to be here today with Lisa, Nikisha, and Kirsten for our discussion.
Great, thank you, Rick. Nikisha.
Good morning, everyone. My name is Nikisha Holder, and I'm an Associate Director of Licensing at Johns Hopkins Technology Ventures. And my focus is really a portfolio of life science-based technologies. I've been a member of the Johns Hopkins Tech Ventures community for 13 years. Interestingly, I started as an analyst and progressed to licensing associate, then to senior associate, and finally to associate director. So I've had the opportunity to kind of function at almost every level at tech transfer, except the highest level. And I've also had the opportunity to manage a group of interns, which is now called our Commercialization Academy, and to also teach tech transfer to those who are interested in entering our career path. I love tech transfer. I love this business and science kind of cohort, and I'm enjoying what we're doing. I look forward to more of this.
Yeah, this has been, and I just as an aside to everyone, the conversations that the four of us have been having each time when we're preparing for each one of these webinars have just been so fascinating. Just to talk about the different perspectives that each of us can bring to licensing startups with university technologies. So you'll get glimpses of that today. We really encourage you to ask your questions throughout today through the Q&A box that's below. We'll talk about that a little bit more. But I do, and first of all, just want to recognize, again, the panelists today. They have spent a lot of time, not just today, but outlining and creating the substance of this series of the webinars. So I really thank them so much for all the time that they've devoted to this.
Thank you for your time too, Kirsten.
Yeah. So before we jump into our content for the day, since we know we have some people on this webinar who may not know who Osage University Partners is we did want to share some brief information. We're a venture capital fund that invests in university academic, I should say, research institution spin-outs, typically through participation rights that they may have in their license agreements. And we're going to talk about this actually a little bit during our webinar today as well. Our partner institutions share in a portion of our profit based on the companies that we invest in from their institutions. So they're receiving an upside for the potential investments that we make in their companies. We're currently on our third fund. Across our 3 funds, we've raised about $600 million, have now invested in over 100 companies from all these different academic institutions. A lot of those have had successful IPOs and acquisitions. And we invest in all stages and all sectors. Anywhere that the universities are creating things in deep science, we're investing in those areas. And so therefore, a lot of our investment team have deep science backgrounds, with most of them having PhDs or an MD. So we'll go on to the next slide. That was just our little OUP spiel. You're going to find this presentation afterwards. Don't worry, this is being recorded. We realize these webinars have been very long. They're an hour and a half long because there's so much substance in each one of these. We realize that some people have to drop off at the hour. You can watch the rest of it later. You can find this webinar either on the OUP portal. We've noted the address here. That is currently only available to the tech transfer offices at the universities that we're partnered with. You can also find this on our YouTube channel. And we'll show you, there's some links that you're going to see in a slide or two about that, where you can also find this. All the people who are registered for this webinar will receive the links to the recording, as well as a copy of these slides as well. And as I mentioned, please do ask questions. We love questions. That's why we're here, is to answer questions. So please do ask those in the Q&A box today. So next slide. Okay, so this is just an overview of this webinar series. So today is the 3rd webinar, so the one that's highlighted here, and we're going to do a dive into term sheets and financial terms. We're going to discuss information that is important for both sides to know when entering into this negotiation for what will hopefully be a long-term relationship that you're going to have. So you can see here that we have links to the previous 2 webinars. One was kind of a 30,000-foot overview of startup licenses out of universities. The second was an overview of the license process itself, as well as some pre-license agreements that can be associated with this interaction. And then we have 2 more that are coming up. So on July 13th, we have part 1 of what we're calling the license section, where we're actually getting deep into the license terms. So you can see the substance of that there. And then we'll have our 5th part in September, on September 9th, which we're calling the lawyer parts, really digging into the lawyer, these particular parts of the license, such as indemnities, warranties, liabilities, and patents, et cetera. So we'll talk more about that at the end, but we can go on to the next slide now. So we do always want to talk about why we developed this set of webinars. So all of the people who are involved in these webinars have spent countless hours explaining many of the same policies and provisions to new entrepreneurs spinning out technologies from academic institutions. And so the questions often asked are valid. For example, why does the university ask for this variety of financial terms? Why is the university interested in doing potentially a term sheet before a full license? Why does the university ask for indemnity? Different types of things. And so we're trying to elucidate those, the answers to those questions with this series so that you can go into your transaction with a lot more information that'll hopefully get you to a resolution and to a license agreement sooner. So I'm going to go on to the next slide. So this is today's agenda. We missed one part from our last part of the webinar series, which was consulting agreements, because we just ran out of time. No problem. So we're going to cover that today. And then we're going to go into the main content of this webinar, which is an overview of what the license grants. This is important for everyone to know, like, what is the purpose? Why are we actually entering into this relationship? Then we're going to talk about field of use. We're going to run through a basic term sheet that Rick has created, but mirrors, I think, very well what you would see from most institutions. And then we're going to run through some basic financials of the license, including upfront fees, equity amounts, which includes anti-dilution, earned royalties, annual payments that may be due under the license, sub-licensing, milestone payments, and patent expenses. All right, let's go on to the next slide, unless my panel has any comments so far. All right, so we're moving back. So this is not the financial terms or term sheet, because we didn't get to this area last time, but we think it's really important to talk about. So we're first going to talk about consulting relationships. Rick?
Okay, thanks, Kirsten. So consulting agreements are a great last topic before we take a deep dive into the license terms. The license agreements themselves convey rights in the innovations and the patent rights and other technology rights, but the license agreements don't give you access to the university's researchers for future development work. And often the researchers are needed to progress the research and development of the technology. And generally, no one understands the technology as well as they do. And so if you want to get access to the researchers, there are two primary ways to do this. The first, which we discussed last time, is a sponsored research agreement. That's between the company and the university, where the company funds research in the lab at the university and is able to leverage the facilities and personnel of the lab. And under that agreement, the university will invariably own the resulting IP, although the sponsor will have the right to license it. So the second way to get access to the university researchers is to hire them directly. And universities typically allow researchers to spend 1 day a week on outside activities that's called under a conflict of commitment policy. And this allows them to engage directly with the startup as founders, consultants, or advisors. In this case, the university is not a party to the agreement. The contract's directly between the startup and the researcher, and the researcher can assign new IP to the startup subject to the university's IP policy. And most universities will not claim ownership of new IP that was created without use of its facilities, equipment, funding, or resources. But you do need to look at the specific IP policies of each university, because some are broader than that and may, for example, claim ownership, even if there was no university facility use, if, for example, if it was in the researcher's field. There often is a disclosure and review process that the researcher must follow within their university before entering into these consulting relationships, and the university may review the contract itself or prescribe certain terms that must be included in the contract, often by way of an addendum that has to be attached. And at the bottom of the slide, you'll see that there's an example linked. If you go there, you could see a sample addendum that's required by one particular institution for its researchers to enter into outside consulting agreements. So that's what we have on consulting relationships. I think we're ready now to take a deep dive into licenses.
That's terrific. Great. Thank you so much, Rick, for covering that. I'm sorry we didn't get to it last time. All right, we're going to dive in now to what a license grants. Nikisha.
So a grant is the main purpose of the agreement. It outlines exactly what a university is allowing under the agreement. So typically there are two types of grants. There's an exclusive grant or a non-exclusive grant. So an exclusive grant, the company's singular permission to exploit whatever the IP in question is in the field of use and in the territory. This means a grant to only one company in that field of use and in the territory. I've also included with or without the right to grant sublicenses. So a sublicense is a contract where the company further grants rights in the technology to other third parties. Most universities will typically limit the ability to sublicense these technologies unless it's been exclusively licensed. I'd also like to note that the exclusive grant must be subject to the retained rights by the university. The university must retain the rights to allow their researchers and other researchers to continue to use the technology. Can you imagine that a researcher has spent 30 years working on a particular technology and the university does not retain rights? Next thing you know, the researcher is unable to even perform these type of research activities in their own lab. So these things are typically against the university policy, so the university will retain rights. Of course, startups typically and their investors will want an exclusive grant of rights. In certain cases, perhaps a non-exclusive right is warranted. This is where the university will allow the company to use the technology, but may also grant the same rights to as many other companies as they wish or other company as are interested in the technology. So a typical grant will convey the rights to make, have made, use, import, commercialize, sell, and offer for sale licensed products in the field of use and in the territory. I'd like to point out a few things on this particular slide. And this is really kind of a primer for some of the other things that we'll be talking about today and in subsequent webinars. First is the fact that there are certain terms that are what we call defined terms or capitalized terms. This means that either the first letter of the term is always capitalized, or perhaps some agreements still have the whole word will be in all caps. And these terms are actually defined in the actual contract. We have the terms here, field of use. We have the term here, territory. We have the term here, licensed products. Again, these terms are actually defined someplace in the agreement such that anytime they're used in your mind, you have to go back to what they're defined as. So definition here, licensed product means any product that cannot be developed, manufactured, used, or sold without A, infringing one or more claims under the patent rights, B, using, incorporating some portion of one or more biological materials, or C, using some portion of related technology. Now, this is a pretty generic definition of licensed product, but I put it here so that you can see how this defined term is now used in this typical grant of rights. Make, have made, use, import, all of that, for sale, licensed product in the field of use. So now Lisa will provide us with a bit of additional insight in the term field of use, which is also a defined term on this slide.
Thanks, Nikisha. Next slide, please. So with the exclusivity decided in the grant part, the field of use can really be the next key non-financial term. And what the field of use does is defines the area that the university is allowing the company to use the licensed patents and or licensed technology in. For example, if a licensed patent might cover a compound that can be used to treat central nervous system diseases, but the company really only wants to use it to treat Alzheimer's, the licensed field of use could simply be therapeutics for Alzheimer's disease. But just like in wanting an exclusive license grant, startups and their investors are often really interested in having the broadest access possible, and that can lead to a field of use of all fields. And a field of use of all fields might be appropriate, but depending on the nature of the technology, the number of parties that might be interested at the time that you're licensing, and the expertise and interest of the company, licensing to all fields to one company might not be the best route. And just as an example, this can often happen if we're licensing a platform technology, or if it's a technology that has multiple really distinct verticals that would be challenging for a single company to develop. And as an example from the University of Washington, we have a coating that has utility for boat hulls, for medical devices, and for consumer products. It's hard to imagine that one company could really effectively develop all of those simultaneously, especially as a startup. So for that technology, it is licensed out to multiple startups that are then really pursuing those very distinct vertical fields of use. As you can imagine, because of all these considerations, the field of use can either be the easiest, if everybody can agree on all fields, or occasionally one of the most complex components of the license agreement to negotiate. You really want to make sure to define it thoughtfully, and that's really why we're indicating the different opportunities here. And just know that it is possible that a field of use, if you have a limited field, might have the ability to be expanded later. With all fields of use, with numerous fields of use, be sure that you would expect that there might be milestones that are related to those distinct fields to make sure that they're being developed. Next slide, please. And I can just
yeah, so now we're moving on to the basic term sheet. So Lisa, go ahead.
Yeah, thanks. So a license term sheet is often the next step after an option agreement, and it really sets the parameters of the license. And what I mean by that is it sets the key financial and business terms. The intent of a term sheet is to expedite the licensing process by focusing on the main parts of the agreement and discussing the elements of the term sheet. And it's really an excellent way to ensure the parties are all on the same page in regards to the full license without having to negotiate the full license and all of its legal terms all at once. And there may be times where the term sheet has already been negotiated as part of the option agreement and was attached there as an appendix. And so that might be the place that you start these negotiations, or it may start de novo, and we're going to walk you through what that would look like. In terms of the format, term sheet is typically just a few pages long. That's really this, purpose behind it is to have this shorter agreement to begin with and to give you a better idea of what to expect. Rick will walk us through a sample term sheet. Over to you, Rick.
Rick, you need to unmute.
Thanks. There's a sample term sheet that you can download. I think we've put the link in the chat. I think the link's okay. The link is in the chat, so you could go there and go download it. And if you want, okay, yeah, we had the web page up already. But if you go to that web page that was on there, you'll see it sort of. I think it's next to on that web page. It'll say session 3, and on the right side there is a link to where it says download it here. So here is a sample term sheet. We're just going to take a very high look through it, and this is really a bird's eye view of the term sheet and the license. And then after we take a quick flip through here, we're going to go back to the PowerPoint and go through each of the key financial and business terms one by one. I like thinking about the term sheet as a blueprint of the license agreement. It gives you an overall view of the key business terms of the license before the license agreement gets built. And actually, by doing this, as Lisa mentioned, it's a key tool and really helps you. It really helps the entire licensing process if you can come to agreement on most of the terms, the high-level business terms, ahead of time before you actually get to drafting the license. So starting at the top of this term sheet, the first two fields we see are licensor and licensee. These are the entities that are going to be a party to the license agreement. The licensor is the university that owns the patents or other rights and is licensing them to the startup. The licensee is the startup that's receiving the license. The next fields we see are patent rights and technology rights that are the subject of the license, what's getting licensed out. The patent rights are almost invariably going to be identified by reference to specific serial numbers of actually filed patents. And we'll cover these listed patents and patent applications and any that are issued from or entitled to priority to the applications that are listed. And beyond patent rights, often there's going to be other things, maybe other things included, depending if the university has things of value to the startup. And here we're using the term technology rights in this sample term sheet. When Nikisha had her description up of the field, the scope of the license grant, I saw it had the term related technology. There's all kinds of different terminology, these technology rights. I've seen associated technology, related technology, but it may be expressed many different ways, but it's a similar idea that there's something else that the university is licensing besides the patents themselves. And this can be unpublished data, algorithms, software, manufacturing know-how, assays, biological materials, or anything else that the university possesses and has rights to that can be of value to the startup. The next fields on here are license grant, field of use, and territory. And I'm not going to spend any time on that. You can take a quick glance in it, but Nikisha and Lisa have already discussed these on the previous slide, so we don't need to spend more time on that now. Next up after that, we get to the financials. And I don't know if we can get it. We can almost get them all on this one screen here, but we'll get down. There's a little more after this when we get to patent expenses, but you can see most of the financial terms right now on this view. There are multiple elements to this, as you can see, and they reflect a somewhat complex risk-sharing arrangement with the university and the startup. And often the university will require only minimal upfront cash payments for technology that may turn out to be very valuable. And the university becomes a partner in the venture by deferring economics for the license grant, but does expect to get compensated if and when the startup is successful. And that's what these kind of complex of array of economics add up to. And if we just take a look down, and I'm not going to spend any time at all on these, but the first item, actually, if you just start, I'm actually listed. So the first one is upfront fee, and that's that's cash payment that gets paid up front. Sometimes it's scheduled out maybe over a couple of years, but that's the idea, is cash for the actual grant of the license. The next is equity. So this is stock that's issued up front to the university for the license, and there's often could be ancillary rights associated with that, which we'll discuss. Next is the running royalty, and this is based on a royalty on product sales. I think this is maybe the most common term that people are familiar with. And as you can see here, and we'll discuss, the royalty is owed to the university based on product sales by not only the licensee and its affiliates, but also its sub-licensees. And we'll talk more about that. Then there's some combination of annual fees. Often there will be just some kind of scheduled annual fees before first commercial sale, and maybe that goes into an annual minimum royalties after that, and we'll talk more about that. After that is non-royalty sub-license revenues. And I'm not going to even sort of start to scratch the surface on that, and we'll talk about that when we get to the slide on that. And that's often kind of maybe the least intuitive of all these. After that is milestone payments and diligence obligation. In order for the university to grant exclusive rights, it's going to expect the licensee to make efforts to develop it, and that shows up both in the diligence requirements, and then there's payments, which are kind of part of this risk sharing element, that as the project's de-risked and the company has more resources, it can pay more fees to the university. Then the final element, the final economic element here, is the patent expense reimbursement. And this is where the exclusive licensee is going to reimburse the company for past expenses and take on the obligation for ongoing expenses during the term of the license. And then finally, in the term sheet, and maybe this isn't in every term sheet where you talk about patent enforcement, it does have an economic element to it, and it often will be negotiated, and we will talk about this in subsequent sessions. And the final element we see here, which you will commonly see in the term sheet, is the fact that there's going to be a definitive license agreement that's going to almost invariably be based on the university's standard form licenses. And this references here is capitalized terms, and there's going to be a lot of standard terms about university use of names, warranty, indemnification, insurance. Those are ones we will cover in the last 2 sessions of these series. And the last thing I want to say before we leave the term sheet is that we saw this array of economic terms, and as I mentioned, often that these will, for startups, these will be back-end loaded. The university is going to try to go easy on the startup at the beginning, often when it's just getting things going and it needs its money, its cash for R&D and to get things going. And so often for startups will be more back-end loaded. The other thing I want to mention about this is that these different elements can trade against each other. So for example, if the company is willing to offer a higher upfront cash fee or more equity, that may help them reduce the running royalty. And in license negotiations, there often are express trade-offs like that.
So before we go back to the slide deck, we did have a question from someone about field of use. Should a startup go with a specific field of use initially and then ask for a second or third field of use after demonstrating fundraising ability? Lisa, do you want to start off with this one since you talked about field of use?
Sure. It's a great question. If you and your startup team have a very clear and deep expertise in a particular field, and that's the field that you start with, that can be extremely reasonable. It means that any potential funders know that your team has expertise in that area, maybe even know that you've been able to execute before in that area, and can see that that would be really your first product. There are times, though, where maybe there are fields that are related, or you can set out a very clear pipeline of how A would lead to B would lead to C. And at that point, it can be reasonable to then look for broader fields. Again, I would say the times where we're seeing that all fields wouldn't be the most direct route for a startup is really where the technology is very broad platform technology, or where the areas which it can be utilized are just such different business fields. And so then I think it's hard to present an argument that you could capture, as I was saying before, it's hard to imagine that one company could have captured marine applications and medical applications and consumer applications. And so for that, the technology and a team that has expertise in one area, that definitely argues for a more limited field of use very well and is investable.
And from the perspective I see it from the licensee side of it, and also especially when there's investors coming in, and all, not saying that all of Lisa's points are totally valid, because from the university's perspective, they want to make sure the technology gets applied as broadly as it can, and doesn't want to sort of strand a bunch of applications with one company that's only developing one application. From the investor's standpoint, often it's, companies pivot and science takes you in different directions. And when investors are making a significant investment, they do have a concern that because the field of use is defined in such a way that they're going to have the technology that's very applicable in other areas, but not have the rights to do it, and go back and go back and negotiate new terms. And so, often we do see, and it really varies a lot, but often we will see, for example, in all fields of use, when the argument can be made for that, although the university may have the right to, let's say, claw back, or not even claw back, but if identified applications, if there are applications identified that the startup isn't commercializing or developing, then the university can go to the startup and say, hey, there's this other application, there's a third party willing to do it. Will you put this into your business plan, or will you sub-license to that party? So that's another common approach to, again, to kind of accomplish the interests of both parties, of the university wanting to make sure that the technology is used broadly, but the company and the investor wanting to be able to pivot and go where the science goes.
Sure. And I think a great example of that we had talked about previously is that you don't know when fields are going to merge. So immuno-oncology is one that we brought up because, 10, 15 years ago, it would have been hard to predict that the technology that you were licensing, maybe in a primarily immunological field of use, would also have application in oncological field. So there are definitely times where we have companies come back for additional fields if they start out with limited fields, or where they can present a very clear route to making it reasonable to have a very broad field, or even all fields of use from the outset.
So we had another field of use associated company question come in, and we actually have a couple of other questions, but I'm gonna hold off on the other questions because they're associated with slides that are coming up. But this one was about when you have multiple fields, how do you handle the IP costs?
So I think that's a really interesting question. If you have multiple fields, there may be an ability for there to be a clear delineation of one company prosecuting patents in that particular field. So you might be able to prosecute based on applications. Alternatively, sometimes the universities will clearly state if there are multiple fields and multiple licenses that the patent costs may be shared amongst the licensees. But typically, if there is an ability to field limit, hopefully there's also an ability to separate out the patent rights out based on their application type. So, you may have a continuation that's in a very specific field, and that's very easy for that one company to be solely responsible for that particular application. Typically, in the case where there is perhaps the initial license to the startup company, they're the first licensee, all expenses will be theirs. But as subsequent licensees perhaps come on with other fields of use, the university will typically disclose that there is another licensee with another field associated with the patent rights. They won't say which company, but they'll let them know so that there is a complete understanding that there will be multiple parties that will be potentially participating in the patent prosecution aspect. Rick, did you have any additional clarity on that?
No, it's always an interesting thing because the universities need to make sure they get reimbursed 100% of what gets spent. So allocating can be a little complex. I did see one East Coast research institution recently that they had a very complex, and I thought was actually really interesting, because what happens often if someone starts initially as the sole exclusive licensee, as a sole field of use licensee, they're paying all the costs, like 100% of the costs. And then you might add a second field of use a couple years later after this first party's paid a bunch of money. And what this one institution did, and it was part of their template, was they said, if that's happened, then this second institution is going to pay 100% until you're even. So I thought that was an interesting, fair catch-up mechanism. But
I like that.
Yeah, yeah. So we have one more field of use question, and then we're going to get back to the slide deck. So the other question was, yeah, that's great. Has your appetite for non-exclusive licenses or defined field of use licenses decreased due to the recent court decisions where non-exclusive licensees don't necessarily have full rights to defend the patents? Have you seen any change in your practices due to that? Lisa and Nikisha. Lisa, you want to start?
Sure. We haven't seen a change to that. We definitely are keeping up on those cases. Although really an exclusive licensee, even though they have the exclusive license, still in every case that I've seen so far needs the university to join them in a suit. So while they have an exclusive license, it's a very rare case where they would also have ownership of the patent. And so the legal enforcement is really tracking the ownership, not just the license. So because of that, to us, it looks very similar and it hasn't changed our practice. I don't know if you want to add to that, Nikisha.
No, I agree that our practices really haven't changed. I would say that perhaps we are thoughtful about when we're thinking of enforcement rights, that we may grant one company enforcement rights while the other one may not necessarily get the same enforcement rights, or we'll grant those enforcement rights in the specific field of use. And potentially, I've seen it where we've added language where the companies have to agree to join in the event that there is some type of infringement action that has to move forward. Again, these can be very complicated matters, and it's something that everyone should think about when moving forward with the contract language. But those are some of the ways that we can try and mitigate complex discussions down the line.
And Rick, your comment from the licensee side on this about the non-exclusive.
Yeah. Oh, well, so in my experience, non-exclusive licensees are never going to have enforcement rights. It doesn't make sense because the whole idea of a non-exclusive is you're sharing that with everyone else. It really comes up more in the exclusive license situation, and the law is what the law is, which is from university licenses, you're almost never going to be able to have standing to go into court alone. You have to have what's called all substantial rights, and the university licenses simply don't grant all substantial rights. So the university will almost invariably have to be a party if there's going to be enforcement action. But then, I think we'll probably cover this in later sessions where you get into who has the first right to bring it, mandatorily joining a party, and how you carve up the money that results from.
Yeah, we'll get into that on the September 9th session when we get to the legal parts. So
yeah, I would agree. I would say typically if the university is granting a non-exclusive right, it will not allow first right to enforce. But if it's granting an exclusive right in the field of use, it will grant enforcement rights in that field of use. And again, we talked about joinder rights. So hopefully that helps clarify the perspective a little bit.
Great. Okay, well, let's move on. Now we've covered the term sheet. We've shown you an example term sheet of what they look like. We're going to now delve into the financial parts of that particular term sheet. And Natasha, we're back in the wrong mode here. That's it. All right, okay, great. All right, financials and diligence. So upfront fee, Nikisha, next slide.
So an upfront fee. So we're waiting on next slide.
I think there's an issue with the, well, I'll figure out the issue with the slide deck.
Sure, I'll keep going. Yeah, an upfront fee payment is in consideration of the initial grants of rights of access to the technology. And I think Rick mentioned this as he was going through the term sheet example. The payment is typically not credible against any other consideration in the license. I'd like to note that the first 3 points that are outlined below have been pulled from a document called Anatomy of a License. And this document was written by our own Kirsten and is still used as a reference with Association for University Technology Managers and with many tech transfer offices. I know I use this Anatomy of a License document to reference things all the time. So an upfront fee can reflect a part of the value of the technology that is being licensed. including some of the resources that have already been devoted to producing the licensed technology. It can be a consideration for the time and effort to enter into the license, and it could be a diligent payment for the upcoming work to be done on the technology. Upfront payments are typically based upon valuations that have been performed by the university using various methodologies, which include review of internal comparables. So what other licenses in this type of field of use indication have we done with this stage of development, and external comparables. Our university routinely uses, for startup licenses specifically, the OUP database that is made available only to OUP partners to identify comparables for startup licenses. We also use tools, external and internal tools, to determine kind of the value of the technology overall, based on, again, its stage of development and a market evaluation. We use these other tools as well for non-startup agreements. So every university is typically going to try and value the technology so we can appropriately assess what the university should receive in return, what the share should be. An upfront payment can be in the form of cash and or stock, or both. Upfront payments can also potentially be spread out over time, especially in the case of startup companies. And we understand that many startup companies are cash poor, specifically if they're not venture backed. I'd like to note that all of these considerations are based on each university's preference and policies. So there are some universities who may offer kind of the startup in a box where there's no fee associated, no upfront fee associated, but there's a required equity, whereas others may require both equity and an upfront fee. Again, the flavors are different based on the university and the negotiation. So again, this is all based on discussions. And so now Rick is going to talk to us a little bit about the equity and associated clauses. Rick, next slide. Rick, you're on mute.
Yeah, we're definitely having problems with the slides. We're going to figure something out on this, but Rick, you start talking about equity and we'll figure this out, okay?
Sure, yeah, I'll start talking about equity. And I think that was a great lead in that Nikisha provided, that every university is different, and what its preferences are and how it's going to go about it is going to vary from university to university. But one thing that has, you know, it's a trend now that it's very common for universities to seek an ownership interest and receive stock in the startup as part of the consideration for the license grant. And, you know, you can call it FOMO, or just the fact that it's difficult for the tech transfer office to explain to the upper administration why the university isn't getting anything when the company is sold for $1 billion or goes public, or it's just, you know, a smart business decision by the universities, because often there will be liquidity, you know, in the form of an exit event before there's significant royalties. So Google is a good example of maybe the best of how taking equity can reap rewards for the university. When Google went public, the stock that Stanford received as part of its patent license to Google was worth over $300 million. From the startup's perspective, as Nikisha said, they should think of the equity issuance as part of the upfront consideration for the license grant, and it will serve to reduce or even possibly eliminate the need to pay the university an upfront cash fee for granting the license, depending on the approach the specific license takes. And this is fully vested stock. There's no vesting requirements. When you sign the license, the stock is transferred to the university and it owns it, even if the license terminates. And generally, this is going to be common stock, not, you know, investor preferred stock. And the one thing the universities are looking at the outset is that their percentage interest is measured after there's a certain amount of financing in the company, because you can get some stock and then the founders could issue themselves more shares or whoever, and then the percentage goes down before any money even comes in. So it's very typical. This is one case where you don't see, I mean, venture capitalists have an own special form of anti-dilution, but this is one case where you're generally going to see some sort of dilution protection through some level of equity financing. So, you know, it may say, you know, the university is going to maintain its X percent interest through the company raising Y million dollars, or through a post-money valuation of a certain amount. Let's go to the next slide.
We're seeing if this works for Natasha. If not, I'm going to start
Yay!
sharing a deck
Woo!
instead.
Okay.
So
And
yeah,
if I
all
can
right,
just-
great.
If I can just remember to unmute, we'll have all of our technical problems figured out. Okay, so the first up here we have is participation rights. And actually, Kirsten mentioned this at the top of the presentation about how the universities, how Osage partners with the university when they assign these rights to Osage. So participation rights go by a variety of different names. They can be called preemptive rights, pro rata rights, rights of first offer, rights of first refusal, same terminology, different terminology for the same concept. That is, the university gets the contractual right to participate in future financing rounds. And these can be structured either to allow the university to maintain its current pro rata interest. So if it had, for example, a 3% interest, then it could buy 3% of the financing, or it could be based on buying a specific portion of the offering. So for example, the license could say, you can buy X% of an offering, regardless of what your current pro rata is. So when I started in tech transfer, it was extremely rare for universities to have money to invest in startups. So I think those rights were put into contracts, but they were rarely exercised. I think Stanford was one notable exception, and it has been investing in startups for a while, but most other universities did not invest. More recently, though, universities have been starting investment funds, which may exercise these rights. And our sponsor, Osage University Partners, was formed to partner with universities in exercising these rights, as Kirsten explained. There's some other rights that ancillary rights that universities may request. Often it's about getting information to keep up to date. So it could be board observer rights or information rights. And there's other special rights. I'd say I see these less often, where participation rights are fairly common. The next item here we talk about is phantom equity. And phantom equity is actually something that universities may ask for in lieu of getting stock. So for example, some universities under whatever the state constitution or their university rules aren't able to hold stock. And so as an alternative, they may ask for phantom equity, which is a contractual requirement to make a cash payment to the university at the time of a public offering or company sale that mirrors what the university would have received if it had been a stockholder. And phantom equity is a very descriptive term of how it operates. It's like equity, but it's not real equity. It's just phantom equity. But it typically goes by a different name in the license. For example, one university that makes frequent use of these provisions calls it an index milestone. So you can see it by different names. So lastly on here, we have the idea of a liquidity fee, which is kind of related and kind of unrelated to equity, because it is a different, it's kind of different character. It's a contractual right to receive payment. Now, not all startups work out like Google did for Stanford, and there is a common fear of universities that they may get essentially kind of wiped off the cap table by dilutive share issuances and may only have a minuscule percentage of the company at the time of sale or IPO. So we've seen this we've seen this from time to time, I guess a little more frequently now, these idea of these liquidity fees. So some universities, either in lieu of equity or sometimes in addition to, will seek a cash payment upon company sale or IPO that is either a fixed amount or is scaled to the size of the transaction. And these can go by different names. Liquidity fee is one, but it can be a change of control fee, an exit fee, or an assignment fee. And from the startup side, the one thing that to be thoughtful of is that if university gets both equity and a liquidity fee, it may be very appropriate to ask to reduce the payout of the liquidity fee by any payout that's received on the equity, because both the equity and liquidity fee are going towards the same idea of rewarding the university at the time that there's a liquidity event, a sale or IPO. So I'll now
We actually have a few questions, Rick, before
Okay.
you pass the baton. So one is, should a startup ever accept a minimum level of equity dilution prior to IPO? So I think the question is, what if there isn't dilution prior to IPO? Unless you understand that differently.
I don't totally understand, because typically the way these anti-dilution provisions work is that the university, and I'm going to make up a number, that there's been a negotiation and the universities negotiated to get 4% of stock at the time of the license being granted. And let's say, and that's going to be translated into a specific share number that the university is say going to get 400,000 shares of stock. And it's got 4%. And what the anti-dilution provision says that if there's more shares issued at the time the company say raises $2 million, and at the time raises $2 million, it's diluted below 4%, the university will just give it additional shares for no additional consideration to bring it up to 4% at that time. So if there's no other dilutive financings prior to an exit event, then the university has its full 4% then. So I'm not sure I fully understand the question, but that's how it operates.
And then we have some more questions on equity. Anti-dilution, it says, is difficult for a university to get in a license. Can this be further explained? So maybe that was a comment that the anti-dilution is difficult. Although my experience is anti-dilution is pretty common now in university licenses. So maybe, Rick, do you want to comment on this first? And
I
then
want to comment on one aspect of it from the side of the company side of things and the concern about anti-dilution rights. When an investor comes in, they're going to want the anti-dilution rights to be fully satisfied as of the time their financing's closed. So what makes investors unhappy is if there's anti-dilution rights that are hanging out after their financing. So if it's structured in a way, and I have seen this overhang in one case. Generally, the investors want it to go away when they invest. So if it's structured in a way that when you do your first price round, it gets taken care of and the shares get issued and the anti-dilution rights go away, that in my experience is pretty palatable for investors. Now, investors have a knee-jerk reaction against anti-dilution. So if they're new to university tech transfer, they may have a knee-jerk reaction against it. But investors who routinely invest in university startups, they expect it and understand how it works. And from their standpoint, they frankly don't care because all the shares get issued and it gets factored into their valuation in which they invest.
Yep, I definitely echo all of that. As we put anti-dilution into our licenses and saw other universities doing the same, having it be very clear that the anti-dilution was to a reasonable Series A, that first investment, really changed the tenor of those conversations immediately. So any companies that we had that were concerned about this possibility that Rick mentions of this kind of overhang or overarching access to additional equity were really resolved by having a very certain number for that Series A reasonable financing when that anti-dilution would end.
If we go back to the previous slide for a second also, you'll see the language on how it's structured. That's going to be dilution protection through some level of equity financing. So, the university will be able to raise to, keep its 4% interest through $2 million raised. And then it's clear. And then as long as that first price round, whether it's a Series C or a Series A, is at least that $2 million, then the university will get issued shares basically simultaneously with the closing, and the cap table's all cleaned up and the investor's happy. Yep. And the university's happy.
Right. So, and another person wrote in that they often hear the argument from a licensee, why should the university receive additional equity when the founders are being diluted in that first round, and what makes the university different?
So I would say that, again, I can't speak for all universities, but in many universities, the equity that the university receives is separate and aside from the equity that the founders may receive. And again, I can only speak for Hopkins. So the founders are negotiating their own personal equity share that is separate and aside from what the university is receiving. And so that's why the university, again, feels strongly. Please recall that all the revenue that the university is going to generate is going to be funneled back into the university for the continuance of research. And of course, the founders, et cetera, will also get a piece. But again, primarily, we want to continue research. And so that's why the university ultimately is going to try and negotiate for its own percentage of equity.
The one other thing I'd say about that and the question of why the founders don't get anti-dilution protection and the university does is the founders are controlling the cap table. And, if the university got 4%, that might mean the founders have 96%. So, you could potentially negotiate a deal where there was no anti-dilution protection, but the university would probably expect more equity up front. So I think it's just kind of you know, kind of the
It's a
economics and where
shifting.
the parties.
Right.
sit.
All right, and then one more equity question, and then we're going to move on. And we actually have a question on technology valuation, but we're going to go through a couple more things, and then we're going to ask that question. This question was, could you please explain the terms deferred equity and delayed equity, and how are those different from phantom equity? Rick?
I've actually not heard those terms before.
Yeah.
I see a lot of these things, and I have not. Deferred equity. I don't know. Nikisha or Lisa, have you ever seen that, heard that, or Kirsten, have you?
So I've only heard of deferred equity. I would assume that it's very similar to phantom equity, that there's some, it would have to be related to some inflection point in the valuation of the company or the sale of the company. There's got to be some reason that you're deferring it to a later time. I will say I haven't seen it in a university license yet.
Yeah.
And if anyone has who's on the call and wants to write in about it, please do let us know.
Absolutely.
Okay. All right. So we'll move on to so 2 slides from here. I think earned royalties. Great.
That's right. Great. So earned royalties are typically a percentage of the monies that are received by the company for sales of licensed products. And just as a very quick reminder, the licensed product is a product that incorporates some of the university's intellectual property. This percentage or value, if you're selling on a per unit or per use basis, is set by using market equivalents. And for the UW and other OUP partner institutions, we have the benefit of using the OUP database that Nikisha mentioned for comparables, but also the Licensing Executive Society, LES, and the Association of University Technology Managers, or AUTM, who we mentioned before, also do have some royalty survey information, and some of that is publicly available. So that can be another good place for comparables. This really helps us set the appropriate royalty rate for a licensed product, much like you would when you're evaluating comparable homes if you're buying or selling a house. The royalties are then a component of net sales, and net sales is the gross amount received by the startup or their sublicensee minus some standard deductions. And those deductions are typically things like allowed discounts, credits due to returns, tariffs, government charges, excise taxes, and shipping and handling. So those are the ones that are very standard. But we also do see that royalties may be adjusted in a number of other ways. It can be because we're accounting for what can be called either third-party royalties or royalty stacking. That's where another organization's patents or intellectual property contribute to the licensed product. And then the royalty is decreased to recognize that multiple parties' IP make up that licensed product that's being sold. There can also be something called a combination product that I think we see most often when a technology is part of a kit. So maybe your kit has 5 different components, but the university's intellectual property is only in one. Then you assess what the correct value is for the university's component of that kit sale. There are algorithms to do that. Sometimes it's also just a discussion between the parties to come up with the right way to recognize their value. And then royalties can vary over time. They can either increase over time or decrease over time, depending on the particular business model and what really makes sense for either having that value go up or having that value go down. And another place where we see royalty adjustments are after the patent is expired. If there's other university intellectual property, maybe that's copyrights, maybe it's trademark, maybe it's know-how, that still is a part of the licensed product. So you're recognizing the fact that one component of the intellectual property is now expired, but there are other components that are still contributors. More recent term that we're seeing, especially in the life sciences space, is royalties on what are called derived products. These are products that utilize the licensed IP in their creation, but where the intellectual property isn't a direct part of the licensed product. This can be a case where maybe you're using somebody's screening tool, that's their intellectual property, to find your compound of interest. So no IP from the university in the compound, but they helped you get there. And we'll cover this topic in more detail in the full discussion of the license webinars that we have coming up, but I wanted to highlight it as that is something that we are seeing more often. And also something that's important to note is royalties are typically set long before a licensed product exists. The licensed product might be 3 to 15 years from the time of the license, depending on what field you're in, especially if it's a therapeutic, it can be at the far end of that spectrum. And so the royalty can be adjusted later when the actual product and the market have really been further and better defined. So just know that as we certainly carefully consider it at this stage where we're setting it into the license, with the understanding that things can change in that time period until you actually are at a product being sold. Next slide, please.
I have a couple of comments before we
Sure,
go on.
go ahead.
The one is one thing from the licensee perspective that I always think bears a lot of thought, depending what the technology is. I think this is probably a little less so on therapeutics, but maybe more on computing or technology products, is the idea of this idea of combination products and how actually your product's going to be sold ultimately by the startup. Because I mean, you could imagine a case where it's a chip technology, for example, where you may set the royalty rates based on thinking that, oh, we're going to do chip sales. But there's a lot of different ways that this could actually work out. You might sell some other kind of subcomponent of a larger device, or you might actually sell a finished device where the chip is just one piece of it. Or you could actually go the opposite direction, and you might be like a soft IP, where you're selling semiconductor soft IP. So there's a lot of different, business models that can come out of it. And often when you're at the startup stage, you don't know, you're doing it. But sometimes you will, take your best guess and or just build some flexibility in. Like, it's possible to have different royalties for different kind of products. If we sell it as this, then these royalties apply. But if we sell it as a finished, device, then these royalties will apply.
Yeah, absolutely. And sometimes if it's being sold as a service, that can have a different royalty as well. So really having good conversations between the university and the company about their expected business model and how that business model could potentially evolve is really important to get this as right as possible at the outset, with, again, that understanding that when you know more, that could change.
And there's one other thing I want to point out about on this slide, which is this bullet point about stepping down the royalty rate after patents expire to recognize non-patent IP that's still utilized. And I think it's something that's kind of obvious to us on the panel here, but just to make it abundantly clear to people who are watching, is that patents have a limited life, of course, and the university can only charge royalties on the patent during the life of the patent. Even if the parties, this is one interesting area, because generally the parties are free to contract however they want, but there's a US Supreme Court case, Kimball versus Marvell, which says patents, royalties on patents after expiration are simply unenforceable. And so you will see in the licenses that you don't have to pay royalties after the patent expire on the patents, but if you are getting some other things, we talked about these technology rights or related technology, or whatever it's called, if you do get rights to that from the university, then there often will be royalties that continue after expiration of the patents, but they will be stepped down to account for the fact that you can't still be charging for the patent, so it has to be a lower rate.
So we do have a question on royalties, and it says, usually royalties change as a function of the value of the product sold. When would a university accept a time-based royalty? And can you give an example? So time-based rather than one of these other things that we talked about.
So I would say when we accept a time-based royalty, there's usually a relation to the value. So it can go either way. It can be that there could be a lower royalty at the beginning while the company is establishing a market. It can be that there's a higher royalty at the beginning if there's a short timeline where the patent is still going to be in existence, and maybe the university is trying to capitalize on that. I haven't seen one that's solely based on time. There usually is this relationship between value or costs in setting up manufacturing that are maybe being accounted for. There are a number of things that can go into that kind of readjustment. I don't know, Nikisha or Rick, if you've seen something where it would be solely time-based.
Agreed. I haven't seen a very specifically time-based royalty, but I have seen royalties that are tiered up or down based on perhaps net sales to the company, and that's typically what I see. It'd be interesting though to look at something that's specifically time-based and understand the reasons why you would have that happen.
Definitely.
The only time I think I've remember seeing anything time-based may have to do with things that are more like software licenses, where you're getting actually licensed to some software, and initially most of the value is what you've taken out of the university, but as you build on that software and it becomes a smaller and smaller component, the university part becomes smaller and smaller component, royalties tear down. That's the only thing I can ever remember seeing something like that, but more frequently you will see these tiers based on annual sales levels.
Yeah, that makes sense. And I think the time frame on a software license is probably going to be longer than a patent, but its value for that time frame is probably going to be lower over time. Right?
Sure.
Right. Absolutely. Absolutely. Yeah. All right. Sorry to interrupt your flow, Lisa. Please go on to the next
No,
one.
it's great. I definitely appreciate the questions. So now we're going to talk about annual payments. These might be maintenance fees or minimum annual royalties or a combination of the two. A maintenance fee is exactly what it sounds like. It's an annual payment that happens usually prior to the first sale of a product. And it's designed really to ensure that the company is continuing to develop a product based on the licensed technologies and really to reflect the value of that technology being licensed. And again, this fee usually ends when sales begin. And at that point, it's replaced by something that's called the minimum annual royalty. Again, exactly what it sounds like. It's a royalty that's used to ensure that the licensee is really committed to maximizing the dissemination of the innovation, including actively marketing it for the lifetime of the license. And it's the minimum amount that the company commits to paying each year in earning royalties in exchange for the license. And these, just like royalties, are set based on projections of sales from the company and or by market standards. And they start low to allow the company to have time to build its market and to really build its sales. And they're creditable against running royalty payments for that calendar year. So some universities set an annual fee that acts both as a maintenance fee and minimum annual royalty, which just means it has like one title, but it accomplishes the same goal, where initially it's effectively just counting for the ability for the license to be in existence, and then it's being compensated against royalties actually being received. And as you might imagine, this is probably the most renegotiated term in a license, especially over this past year and a half where things have been so different in market spaces. This is a place where we have spent a lot of time with our licensees coming up with something that's fair and equitable. Similar to royalties, they're usually set, years before a product is actually sold, and the eventual product and its time to market or its market acceptance, if you're going through a regulatory process, can change so dramatically over the course of a license that this is something where if you as the company know that your minimum annual royalties are just not at all in alignment with your product and sales anymore, talk to a university early. We understand that can happen. We know that markets can redirect and sales can change. And so this is definitely a place where we'll amend a license. It doesn't make sense to us to have something that really prohibits the company from thriving. So check in.
We have a couple more royalty questions, Lisa, if it's okay if I put those in now. Are you finished with it?
Yeah.
Because I think actually this gets to some of this, but also on the royalties, is that a couple people wrote in about the fact that sometimes the companies, push for lower earned royalty rates, but the universities perhaps find out later that a higher earned royalty would have been more appropriate. Is it a common practice then to try to adjust those royalties later on and increase to the universities? And I know what my answer is to this, but I'm curious if anyone would have a different answer.
So I would say that is incredibly challenging. I don't know that I've ever seen a royalty go up. And for the company that makes sense, right? You have an agreed license and it was based on your best knowledge at the time. There may be some way that, clearly because of the data, because of new actual information that you have now. So not just a feeling that you'd like a higher royalty, but some like very substantial, clearly defined data. You're totally off base. That's definitely a reason to at least try to have that discussion. how likely it is that that'll change. The royalty really just depends on the relationship between the company and the university, and sometimes between the university and the company's attorneys. But yeah, it is almost infinitively, more likely that you're going to see for a royalty to be asked to be stepped down. And I don't know of a case where a university's been able to have it step up.
I have one example, actually.
Okay.
Great.
One example, when I was on your side of the table, where we had a situation where the university actually negotiated a license where royalties didn't start until the patent issued. So the more typical scenario is that royalties start even while the patents are pending. And that maybe comes as a surprise to some people, but that is the typical structure. And we can get into the debates of why that, but that is the typical structure. And for some reason, the university where I was had negotiated something where there wasn't a royalty. And then the company started selling products before the patent was issued, and everyone kind of realized it was really unfair, to the university and the researchers who were very involved, and they weren't getting a share of it. So, so we did go back to the company and say, hey, would you mind paying some royalties? And of course, they asked for a concession in return, but we worked something out. Yeah. So that's my one instance of.
I would say that is part of the reason why universities will probably negotiate to try and have a higher royalty at the onset, because it's so difficult to try and negotiate a royalty going up, coming back. Again, we certainly consider different changes and pivots of the industry and the marketplace, such that perhaps there's an ability to go back and say, what did we anticipate was the value of the technology at the time that we did the license? And what is the value of it now? And is there a way that we can come to terms so that we'll still get the same as what we anticipated based on what the market stance is now? But again, typically the university is going to try really diligently to try and get a reasonable royalty upfront versus trying to negotiate later.
There's one I want to just point out. There's one interesting negotiating leverage point on this, which is the university can't, if the licensee complies, the university has to, can't get out of the license. Where maybe there's some more leverage on the company side, which it can always drop the license, it can go after other technologies, or what often frequently happens is if the investors or partners say we can't do the deal based on these economics, then everyone comes back to the table.
Yep. Right. And we had one agreement where the company, as they got into manufacturing, realized they were going to need to license in another component, and that was going to completely change their cost of goods. And so we amended our royalty with the understanding that if at a later date they were able to get that component less expensively, we would have that discussion again. So.
Right. Yep. And as you're pointing out, renegotiation is common, because when you're taking this license, you do not necessarily know all the pieces that are going to come into play for you as a startup company, or as a non-startup company as well. And so the university is very willing to listen to that and to adjust, because they want to see these products out there and having an impact. So we have one other question on minimum annual royalties for non-therapeutic technologies that take a long time to reach market. Are annual minimum royalties common?
They are. So in my space, which is medical devices, we definitely see that. They can have a similar timeline to therapeutics, maybe not quite as long, but also generally, at least 10 years before a product is approved and marketed. Again, the minimum royalties are being set against the company's projections and against market projections. So we're really trying to make sure that it's equitable, and it's meant to really reflect what the company's anticipated minimum royalty is going to be for that year. So the goal is that they would essentially never pay this amount, because their projected royalties are always going to be higher than this set minimum.
And then one last royalty question, and then we're going to try to get through our last three subjects in the next 14 minutes. Mention was made of a new royalty fee structure for pharma. Could you please elaborate?
So I think that's probably maybe that's when I was mentioning that it can be a derived product. If so, then it's a fairly new term that's been coming up, where folks are interested in getting some value for how their technology, their licensed technology, was utilized to identify potential therapeutic, diagnostic. It can be used in other fields as well, but that's where I'm seeing it more often. And so it would not be in the same range as a royalty if your intellectual property was directly a part of that eventual licensed product, but it's a way to potentially compensate for the utility of your technology in getting the companies to identify that future product. So, and it's not the only way. That can be done, simply by an upfront fee or milestones instead. But that's definitely a new thing that we're seeing, and again, primarily in the life sciences space.
Great, thank you.
Sure.
All right, we're going to move on now to economics, to universities from sublicenses. Rick, let's move on to that. Oh, you're muted, Rick.
That's 3, Tom. Maybe I'll leave it unmuted. Okay. So sometimes, startup founders like thinking, why do I need to worry about the sublicense? I'm not planning on sublicensing. Well, the ability to sublicense, we're going to go more into the sublicense rights in our next session, but the license agreement is generally going to allow you to sublicense. There's going to be some conditions around that, but you're going to have that right. And even if it's not in your immediate business plans, it's a good thing for you to have this right, because it gives you the flexibility down the road to sublicense as appropriate. And so at the term sheet stage, it's important for the startup to understand how the economics of sublicensing work, even though they may think they don't need to care about it. And when I started in tech transfer, I found sublicensing economics to be the most confounding aspect of license agreements. And for many startup founders, I see it takes a little bit to wrap their heads around these terms. So I'll try to demystify it a little bit. And there's 2 separate income streams related to a sublicense, and they get treated very differently. The first has to do with product sales and royalties. And as mentioned earlier, the royalty is payable by the startup on product sales, regardless of whether the product is sold by the licensee or sublicensee. So the university negotiates its royalty rate, and it wants to get paid that rate regardless of who sells the product, the licensee or the sublicensee. So to state what may be obvious, then it's incumbent on the licensee to charge the sublicensee a high enough royalty rate to cover its obligations to the university, and the startup will be able to keep the positive spread between the university license royalty rate and the sublicense royalty rate. And it's also incumbent on the licensee to get reporting and collection from the sublicensee, because it is the licensee's obligation to pay the university. So that's the economics around selling licensed products and royalties. The second income stream that plays into the license agreement is, call it here, non-royalty sublicensing consideration, and it can go by many different names in license agreements. It could be sublicensing income or sublicense revenue, but I think non-royalty sublicense consideration can be the most descriptive. Now, this category of revenue includes upfront fees, annual fees, milestone payments, and other payments made on behalf of the grant of the sublicense rights apart from the royalties. And the university will get a sublicense fee calculated at a specified percentage of this income at a rate which is higher than the royalty rate. Often these sublicense fee percentages will tier down based on the accomplishment of milestones. And sometimes you'll see it based on the passage of time, but more frequently it gets negotiated to tier down based on the accomplishment of milestones where the company's added more value and can justify paying a lower portion for sublicense fees. And there are some common and some negotiated exceptions to what payments the sublicense fees apply. For example, a common exception is if the startup receives equity or debt financing from the sublicensee at fair market value terms, then that will be carved out and you don't have to pay a percentage to the university. And there may be other negotiated exceptions. For example, R&D expenses that the startup may be required to incur related to the sublicense program. From the startup's perspective, if the upfront sublicense fee is fully earmarked for R&D expenses that the startup has to incur under the sublicense, it can be problematic to give a significant chunk of that to the university. So that can get negotiated out, during the license to get something that meets the needs of both the university and the startup in that case. And then one final point on sublicense economics and these sublicense fees is that if there's additional IP that's going to be included in this sublicense, so let me just take an example of a startup that's licensed patents from 2 different universities. So, and it may be that it's going to sublicense them as a bundle to a third-party sublicensee. And in that case, it may be appropriate to have some sort of provision to apportion or allocate the sublicense revenue that's applicable to each license. So now, in the interest of time, I'll turn it over to Nikisha to talk about.
We have one question on sublicensing. I'm sorry. I keep getting. I know we want to move on and finish all our subjects, and we're going to. And actually, this question actually is more for Lisa and Nikisha. So Nikisha, maybe you can start off. Can you give a little more color on whether universities prefer to grant sublicensing or not, and how important is it to fight for sublicensing?
So I would say typically for an exclusive grant of rights, the university is happy to grant sublicensing rights. So typically a company doesn't have to fight for it. We're going to give it to you. For non-exclusive rights, typically a university is not going to want to grant sublicensing rights. So I think that should hopefully answer that question.
I think it does. Yeah, thank you. And we'll talk more about sublicensing in one of our, I think it's our next webinar. So great, next slide then. Sorry, Nikisha.
No problem. So milestone payments and milestone events. So universities don't ever want to provide a license to a company only to have that technology languish and not be developed into a product. Typically, when we enter into an agreement and we have discussions, both parties are super excited about how hopeful the technology will be developed to its full capacity. But we all understand that sometimes these things don't happen. So a mechanism to ensure that the technology is developed to its fullest extent is the inclusion of milestones. And so milestones are important in a license agreement to ensure, again, that progress is being made, and further it allows the licensee to share in the upside upon reaching certain milestone events that typically will increase the value of the IP that's been licensed. Sometimes these milestone events are called diligence or diligence milestones, and they are encouraged by the university to ensure, again, that it's being developed. Milestones or milestone events are typically identified in a development plan. We talked about this development plan I think at the first webinar that we did, that's provided by the licensee or company to the university. Importantly, so again, let's go through the slide. Listed below are a couple of common examples of milestone descriptions. However, the type and description should appropriately be customized for the technology. So most of these listed below are appropriate for a therapeutic or diagnostic. A device-based set of milestones might be a little bit different. A software-based set of milestones might be a little bit different. A prototype might be included in there somewhere. Importantly, it's important that if milestone is missed, it's considered a breach of the agreement, and the university will have the ability to terminate the license. But practically, let's step back. I don't want that to scare anybody. Practically, the university does not want to terminate a license, and rather it wants to allow a missed milestone as an opportunity to engage in discussions with the company about why it's unwilling or unable to meet the milestone. And the result, we've talked about this throughout today, may be a renegotiation of the milestones or timeframes that will allow the company to meet certain milestones. This particular table outlines milestone events that have both a date and a date and a fee structure. So it's a combined diligence and kind of regulatory events type milestone. Next page, next slide. So this particular grouping or set of tables outlines milestones that are separated as diligence milestones versus regular event-based milestones. And so in the top table, you'd see milestones where we'd have a fee associated versus the bottom slide where you'll have milestones where you have dates of accomplishment associated. And I'd like to point out that I'm very passionate about milestones. in particular with startup companies with perhaps a novice or inexperienced management team. For the sake of ensuring that the technology is moved forward, I've sometimes included some seemingly insignificant milestones that everybody kind of raised an eyebrow as to why I was doing or including them. For example, a company needed to acquire a space to do a set of research experiments that they wanted to do, that they needed to do to reach the third milestone. And so I put in the agreement that within 3 months of executing the agreement, they will have secured a space so that they could meet the next set of milestones. Again, there was no money associated with this milestone, but simply a mechanism to make sure that they were meeting certain requirements so that the technology could be further developed. And I think with that, I will pass this on to Rick, who will talk a little bit about patent prosecution expenses, unless there are any questions.
Okay, I'm unmuted and we are on the final topic point of the term sheet. And this has to do with both patent prosecution and expenses. And the first point to note is the responsibility of the parties and how that breaks down between the university's role and the licensee role. The position of most universities is that they own the patents, and it's important for them to maintain control of the patent prosecution process, doing it with their attorneys. And although that's the case in the way most licenses are structured, not all, but most, typically the licensee has the right to review and comment on everything in the patent prosecution process and the filings. And in practice, an exclusive licensee may play a significant role in guiding the prosecution based on the commercial direction of the technology. The second point on this slide has to do with the financial responsibility for the costs of filing and prosecution. And as we've alluded to before, the university is going to pass those costs on to the exclusive licensee. And the past patent expenses are typically going to be due at license signing, but may be scheduled out over time if the past costs are significant. And future expenses are going to be due when incurred, although in some cases, the universities may require advance payment of expenses to ensure that they do get paid. For example, it's going to be like a large expenditure for doing a nationalization of a PCT. And we talked about earlier how allocation among licensees, if there's field of use licenses, can be done and can be complicated. Most universities take a fairly unwavering position on the exclusive licensee covering patent expenses. As far as the ongoing patent expenses go, the decisions on what and where to prosecute are generally driven by the licensee, and it's not an expense the universities have an infinite budget to bankroll. And in terms of past patent expenses, the universities see the replenishment of these and reimbursement and replenishment of their patent budget as an important source to help fund their patent budgets, which are finite, and allow them to speculate on new patents and keep the cycle of tech transfer going by investing in new technologies. And then because the licensee is financially responsible for the patent costs, it will drive decisions on where to file outside the US. And the university is definitely, you're usually going to follow the lead on the licensee, the exclusive licensee. And the licensee generally will have the right to remove patents from the license with specific advance notice so that it doesn't have to keep paying for a patent that it doesn't see sufficient value in.
And we do have a couple of questions, and we have 1 minute left. So, if for anyone who is still on, we do have a survey. Please fill it out as you leave. It's also going to be a link for it in the chat. We do these surveys, make these webinars happen. We adjust our topics based on the web questions, the points that you all bring up that you'd like to hear from us from. So please do answer the survey if you can. It's very short. Okay, so this person has been waiting for an hour to hear the answers to their question because they wrote it down, but I knew we were getting to this slide, and so I wanted to ask this question at the right time. So what typical patent reimbursement timeframes have you seen, and for these payment plans, as you already mentioned, Rick? And this person understands that there are trade-offs and may depend on the business plan and revenues, et cetera, but what kind of timeframes are you guys usually seeing? And Rick, do you want to go first and then?
Sure, yeah, I'll just share my set of experiences. I think a typical one may be scheduled out over 2 years and maybe accelerated if a certain amount of equity financing is raised. So that's one that I think is fairly kind of median in my experience.
That's pretty standard. I would say it can be adjusted depending on the level of past patent expenses there are. So if it's, you know, fairly minor, maybe there's only a provisional patent, your expenses are, you know, $1,500 or below, that's usually going to be due within the first year and won't be tied to a financing. But if instead we've had companies that have licensed portfolios, startups that have licensed portfolios, and the past patent costs can be over 100K. And so wanting to make sure that the startup is financially on its feet, that's something that we're certainly going to time out over a longer period of time, or until there's a major financing.
I agree. I think it's important to note, though, that ongoing patent expenses are absolutely required by the license to be paid by the licensee on an ongoing basis.
Okay, and last question, does the exclusive licensee pick the IP law firm or does the university? Nikisha?
So it depends on the university. So I know Hopkins has a set of, well, so the company can have its own intellectual property attorneys, and the university will typically have its own law firm. Recall that the university will retain rights typically to lead prosecution for lead the patent prosecution. And so they will have their own attorneys. In some cases, the university may allow the company to choose the law firm. Hopkins has a set of approved firms that you can choose from. And again, those will be separate and aside from the company's own independent legal team.
Yeah, and I would say that also as the company may be adding their own intellectual property and developing further technologies with the university, those co-owned technologies are typically then, more often than not, I guess I would say, led by the company and choosing their attorney to lead those. And so it's possible then at some later point, you may then combine the portfolio under the company's attorneys.
Great. All right, well, thank you so much. We're going to go ahead and move on. I know we're already a little bit over time here, but I do want to move on 2 slides from here to just note that our next session is on July 13th, where we're going to go through some major parts of the agreement, ones that are most often, I think, negotiated or there are questions on, especially by startup companies. So we'll be going through these particular sections on the session on July 13th. And in the meantime, I would like to thank our terrific panelists today for their expertise and time and everything they did in preparing this session and all the previous sessions and the upcoming sessions we have. We'd also like to thank our audience, especially those of you returning or joining us for the first time and perhaps are interested in reviewing the future sessions. Please give us your feedback. It really is important to us. It helps us determine what to do in the future. And one other thing I meant to note earlier, just in case people were curious because I'm really amazed at how many of you have stayed on so long, especially since we've gone over. If you do want to see example startup licenses or option agreements or term sheets, as we've mentioned, Rick did provide the link to that one term sheet. But early on in this series, we'd actually provided you links to agreements that are online that you can go ahead and see what standard licenses or option agreements or other types of agreements are from universities. You can often just Google the university's name and license agreement and something will pull up. So that'll also help people along with their startup licensing journey to kind of see how these agreements work. So thank you everyone for joining us today. Do reach out with your questions and we really appreciate everyone's time. Have a good one.
Thanks everybody.